Alrighty. Hello. Good afternoon. Today is Thursday, February the 15th, 2024. My name is Ashley Glover, and I'm here with Kim Christian, and we are happy to welcome you to our webinar. What is your spouse good for? That's a great question, and what a better time for this webinar than the day after Valentine's. We had a little fun with the slides, so you may notice a little festive touch with some hearts and pink fonts here and there. So let's go ahead and get kicked off with a few housekeeping items. This presentation is scheduled for a half hour. We put together the PowerPoint, which hopefully you're all seeing on the screen along with our webcams. To help minimize background noise, your mics are muted, so please use the Q&A box to submit questions. We've saved time at the end to answer as many as we can. Feel free to message other attendees in the chat box. We are recording and we'll email a link to the recording. And finally, we always value your feedback. So please let us know how we did in the webinar survey. That survey will appear on your screen when the webinar ends. Now I'd like to introduce today's presenter, Kim Christian. Kim is a dedicated partner with Russo Law Group. She's the lead planning attorney in our Lido Beach office, but she also meets clients in Garden City virtually and home visits. She's been with the firm for over 15 years, helping clients with elder law, Medicaid, special needs, estate, and trust planning. Finally, Kim was recently recognized by Lawyers of Distinction for her practice in the, for her expertise and excellence in the practice of law. So, Ms. Christian, thank you for being here. I'm going to hand it over to you.
Good afternoon, everyone. Welcome. Thank you for joining us. The moment of truth. What is your spouse good for? At least in the legal context, I will answer that question. I'm not sure I'm qualified to answer in any other context, but nevertheless, we're going to cover Medicaid rules and your spouse, estate tax planning and your spouse, and retirement accounts and your spouse. And there's so many other areas in the law where having a spouse is quite meaningful when it comes to executing a plan. So I've picked three major categories. Doesn't mean there's not more. Perhaps we'll do a part two of what is your spouse good for. But I think these are some good ones to cover today. So Medicaid rules and your spouse. So there's something called spousal refusal, and this is in the Medicaid arena. So as some of you may have heard, Medicaid is the payer of long-term care, and the cost of care in our area is quite high. If you need a nursing home, the cost of care is running an average per month about $15,000 to $16,000 a month. If you need home care, it's not far behind if you need 24 hours a day, 7 days a week, right? So Medicaid says you can't have too many assets or we're not going to cover your care at $15,000 a month, for example. So they instituted something called the 5-year look back. And the 5-year look back is a rule that says from the date you want us to cover you in a nursing home, we're going to look back 5 years and we're going to see if you made any transfers out of your name. And if you did, we're going to penalize you. And sorry, you're going to have to privately pay until that penalization time is up. And when you're faced with a private pay at $15,000 a month, it's quite disconcerting. So what is your spouse good for? There is something called spousal refusal. And what that means is if I need care and I never transferred my assets, for example, to a trust, I never got the 5-year look back moving, I still have all these assets in my name, and now I need a nursing home, how am I going to qualify? Well, if I have this well spouse who lives in the community, I am entitled to take my assets and transfer them to that spouse. And then the spouse can refuse to contribute toward the cost of my care, not out of lack of love and affection, and they get to keep the assets and they get to keep the income or their income. And that's a really important benefit to having a spouse. So if I need nursing home care and I'm married, I can implement what's called spousal refusal. I can give my spouse all of my assets that are above the resource allowance that would have otherwise prohibited to me to be on Medicaid. I can transfer them to my spouse and they can refuse to contribute toward the cost of my care. I then go on Medicaid, even if it's within the 5-year look back period. So that is a huge one, spousal refusal. My spouse is good for that. So just my prongs, even within the 5-year look back, the applicant's spouse may transfer his or her assets to the non-applying spouse. The applicant's spouse may need the income and assets to still live in the community. It's really important. That's kind of the philosophy behind it. The applicant's spouse refuses to pay for the spouse's care, again, not out of lack of love and affection, but they need to still live in the community. And at that point, Medicaid is approved. So I like to start with this one because this is really practical. I mean, this is often implemented because not everyone had the opportunity to plan in advance. And although you should plan in advance and not rely on spousal refusal, your spouse is good for this if you're ever in a crisis. So there's also something in the Medicaid rules called spousal allowances. So for example, if I'm on Medicaid home care, I'm entitled to keep $1,697 of my monthly income. If I'm on nursing home, I get to keep 50. And this is subject to other rules like a pooled income trust where I can get some of my income overage back, right? This is a very general webinar. But those are the rules for the applicant. But the spouse gets what's called a spousal allowance. And before I give any of my income to the nursing home, if I need it, I am permitted to raise my spouse up to $3,853.50, simply because they're the spouse. So again, my spouse is good for getting a higher spousal allowance if they remain in the community because I need nursing home care. All right. So we just talked about Medicaid planning. I hit two of the major prongs as to why a spouse is good in that arena and how we can use the fact that we're married to shelter and protect certain assets and get the health care coverage that we would otherwise need. So now let's move to a different arena. Let's go to estate tax planning and your spouse, right? We talked about healthcare. Now let's talk about taxes. Talk about romantic. All right. So estate taxes, and I say estate, E-S-T-A-T-E, not state, taxes are affectionately known as death taxes. Did I die with too much money in my name? And if I did, the government would love to tax me on that. And how do they determine whether you died with too many assets in your name, whether you had a taxable estate? Well, they add up all the assets that you owned when you passed away, your real estate, your bank accounts, your cash accounts, your annuities, your brokerage, savings bonds, life insurance, all of the ones that are up there on the screen count. Retirement accounts, right? They are all part of your taxable estate when you pass away. So there's two exemptions or two thresholds that you have to meet. Federally, I can die in this is 2024, I can die with $13,610,000 in my name. Anything below that, I will not have a federal tax. In New York, my tax exemption is $6,940,000. So I am allowed a credit of that amount. And if I'm below that, I am not taxed. But if I add up all the things that I had on the prior slide and I am over that exemption amount, then I'm going to have an estate tax. And you're looking at a top rate federally of 40%. In New York State, you're looking at 16%. So it's really important, that you're mindful of the size of your estate to make sure that if there's anything we need to be doing to reduce or eliminate estate taxes, we're on top of it. So what's my spouse good for in this arena, right? That's the next question. So there's gift rules. Gifts between spouse, or if I pass away and I give it to my spouse, those are exempt from federal gift tax. So if I have a credit and my husband has a credit, maybe I gift him some of my assets so he has some of the money on his side of the ledger to use his credit, and I have some of the money on my side of the ledger to use my credit, and that's called asset allocation. We want to make sure that each spouse is holding a substantially equal amount so that we can take advantage of both of our estate tax credits. And between spouse to spouse, in my lifetime, I can gift as much as I want. I can hand it right over, and there's no gift tax concern because it's your spouse. So there's two elements, or two main elements, when you're doing a what's called a disclaimer plan. I can put in my will or in my trust that when I pass away, I want everything to qualify for what's called the marital deduction. Because if I pass away and I give it all to my spouse, then I don't have a tax on the first to die, right? Because everything that goes to my spouse is exempt. So I start with a clean slate. I say, I want everything to qualify for the marital deduction. I'm going to put it in a marital trust for the benefit of my spouse. They'll be entitled to the income, right? And we'll be confident that anything that went in that direction will not be part of the first to pass away's taxable estate. With that said, you don't want to put everything in the spouse's name, because then your spouse might have too much money when they die. So on the next slide, you're allowed to create what's called a credit shelter trust. And the credit shelter trust is a trust for the benefit of the surviving spouse and the children. The assets of the first person to pass go into the trust for them. And by putting it in this trust, we guarantee that we are using the first person to pass away's credit, and anything that goes through that credit shelter trust is going to go estate tax free. So because we are married and I have a spouse, I could take advantage of what is on the next slide. And that is the marital disclaimer plan. The first spouse to pass away funds the marital trust for the surviving spouse, but they have the option to disclaim all or part of the assets so that it can go into the credit shelter trust for the benefit of the surviving spouse. And I can take advantage of my credit because I'm the first to die. And I can also take advantage of my spouse's future credit when they pass away. So this is a fantastic plan, and it's used often as a tool when there is a married couple and we're concerned about estate taxes. So I alluded to this before. It's called asset allocation. If New York says I'm allowed a certain amount and my spouse is allowed a certain amount, and the federal government says I'm allowed a certain amount, and my spouse is allowed a certain amount, and if I'm under that amount, then I don't get taxed, then I want to make sure that my spouse is holding some of the assets and I'm holding some of the assets so that we are not lopsided and we don't run the risk of not being able to use both of our credits. So we're going to take advantage of the New York State exclusion amount. It's critical you review all of your asset holdings to make sure that they are allocated properly. And you want to be reviewing your ownership and beneficiary designations as well. Also super important to make sure that things are flowing the proper way. Now, without asset allocation, you can run into a situation where you actually lose the exclusion amount, particularly New York State. And we don't want to do that, because if we lose that exclusion amount, we've wasted a credit. And in some situations, it may result in a very significant tax. Okay. So here we go again, 2026. So I share with this all the time. The laws are ever changing, and we have to make sure that we stay on top of things so we can make sure that you're on top of things and you know what's going on. So at the moment in 2026, the federal and state gift tax exemptions are scheduled to return to 5,900,000 approximately. That is a reduction, a significant reduction from what we have now. It may be sooner if Congress, along with the president, decides to change the federal and gift estate tax laws, but that's where we are now. It also may never come to fruition in 2026. So this is what we're seeing at the moment. This is a snapshot in time. So there's no downside if the gift tax exemption is used prior to 2026. So maybe what we do is we analyze our estate to see if we should be taking advantage of exemptions now in the event things are reduced. Okay, so there are tax planning opportunities, taking advantage of the exemption. If you're married, that's the theme today. You can do what's called the credit shelter trust and the marital trust. That is the disclaimer plan I talked about. Remember, from spouse to spouse, there's exemptions. So we want to make sure we allocate the assets properly. So we are taking advantage of both spouses' exemptions. All right, so let's go to our third theme, retirement accounts and your spouse. All right. So if anybody has a qualified retirement account, in this instance, my slide is referring to a stretch IRA. It's important to understand the prior law so we can talk about how important a spouse can be under the new law. So under the prior law, a designated beneficiary, a spouse, a child, any individual, could stretch the payout of an inherited IRA over his or her lifetime. That's really important, because when you take distributions from an IRA, that's considered taxable income, right? So if I inherit an IRA and I'm able to stretch it over my life, then I can take a slow income tax consequence. I could take a slow withdrawal over my entire life instead of being subject, for example, to a 5-year payout. If I have to take a significant IRA out within 5 years, then for those 5 years, that is a heavy income to me. So the stretch over the lifetime and the prior law is of great significance to why the spouse is important now. So let's see what happened. The new stretch rules. There's a general overarching rule. Instead of allowing the IRA to be stretched over the beneficiary's lifetime, it now has to be taken out within 10 years. So if I leave my IRA to my child, they have 10 years to take it out. That is different than being able to take it out over a person's life expectancy. It's a much shorter withdrawal time period, with results in withdrawals at a higher rate, causing significant income. but there's an exception. And the exceptions to these rules, and I've put them up here, I've obviously started with the surviving spouse. If I was married when I passed away and I designated my spouse, what are they good for, as my primary beneficiary, then I am able to, my spouse is able to stretch the withdrawal still over their lifetime, and they are not subject to the 10-year rule. That is tremendous, right? Because it can very often be more than 10 years that the surviving spouse is alive. So that is very helpful. Now, there's other exceptions. There are beneficiaries who are disabled or chronically ill, beneficiaries who are not more than 10 years younger than the original account holder, and beneficiaries are minors, but only during the period that they're a minor. So these are very, very intricate and tricky rules, and you should be speaking to us about how your beneficiary designations are allocated or designated so that we can make sure that you are getting the most favorable tax treatment possible, right? So now the general rule is you have to take it out within 10 years if you're the beneficiary of an IRA, unless, ding, 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 number one, you are a spouse. Then you are able to stretch it over the surviving spouse's lifetime. And then, of course, there's other exemptions that follow. I've put them on this slide just for your knowledge and review. So before I get to when I should update my existing plan, and I promise I'm going to save time for questions. I know somebody had already asked me one, so I will do that. But I just want to say that we talked about Medicaid and spousal refusal and how important that is. We talked about spousal exemptions when it comes to New York State and federal estate taxes. And we also talked about the spousal ability to stretch over a surviving spouse's lifetime when it comes to inherited assets, inherited IRAs. So it is very, very important. And I know we, made a little joke about what is your spouse good for, but in these instances, they really are good for something. So when and why should I update my existing plan? Well, my rule of thumb is every 3 to 5 years, you should be coming in for a checkup. You go to the doctor, you should go to your estate planning lawyer and make sure that your plan does what you think it does and says what you think it means. It's really important. And I pointed out to you that the laws change all the time. So you just want to make sure that it's up to date with what's going on. Also, there's triggering events upon the occurrence of a marriage. I love that that's the first one in light of our theme. You have a new child, there's a divorce, right? That matters. There's a major change in assets, somebody's retiring, there's a health diagnosis, or a loved one passes away. All very important. All right. So, Ashley, what's on the next slide? Well, what do I do now? You got to create a plan. You got to make sure legal documents are comprehensive and up to date. You got to get your plan implemented. Being proactive is probably the most important thing a person can do. And if you're not, then there's always something we can do in a crisis. But typically, we recommend planning when there is no crisis to avoid one. All right, so in sum, we have the Medicaid rules and your spouse, the estate tax planning, and the retirement accounts and your spouse. And I think we can all agree that these areas really support how a spouse can help or how being married can help in a particular situation. All right, so I feel that we have a few minutes left. I can answer some questions. Before I do that, I think Ashley wants me to tell you that we have, because you attended, a reduction in our planning meeting fee. Typically, our planning meeting is $600. We review all of your existing legal documents. We recommend a plan for you. We set forth the legal fees in advance, what that plan is going to look like, and typically our fee for that is $600. But because of your attendance today, if you reference this seminar or webinar, we will give you a $200 discount so that the planning meeting is in fact $400 instead of $600. There is a limit on that. I believe it said it should be used or at least called before March 15th of 2024. All right, questions? So Ashley, I'm going to have you help me out with this. I know we got one in advance, which I love.
Okay. Let's see. If your spouse elects to use a charitable remainder trust, do all of his assets have to be in the charitable remainder trust? And if they are not, can the spouse have more than one trust at death?
Excellent question. Okay, so when does a person use a charitable remainder trust? Typically, a person will use a charitable remainder trust when they want to help plan for major donations to charities that they support. And the benefit of doing it is it allows to defer income taxes on the sale of assets transferred to the trust. That's one reason. And it may allow you to take a partial charitable deduction based on the value of the charitable interest in the trust. So many people use this when they're doing estate tax planning and they're minimizing estate taxes because it gives them a way also to benefit their charities, right? So the question is, if I set up this kind of trust, or my spouse does my spouse have to put all of their assets in their trust and it's subject to that? Or is it not an all or nothing proposition? Perhaps I put some in the charitable trust and I leave some in a revocable trust that has the credit shelter trust provisions, for example, or the marital trust provisions. So the answer is it is not exclusive. You can have multiple trusts in your plan, and you just have to make sure that it fits your plan properly. As you know, I said this before, this is a general webinar, so it doesn't necessarily apply exclusively to your plan, but as a general rule, you can have different trusts. You do not have to put everything in it.
Okay. Next question. I inherited an IRA from my parents. Is the inherited IRA free from any creditors? Can I name the beneficiary of this inherited IRA my revocable living trust, which by its terms has my spouse as the sole beneficiary?
All right, so I think I'm going to have to
Uh,
click on it because it's a multi-part question.
I was gonna say it might be
And,
easier.
in light of Valentine's Day being yesterday, a little too much chocolate, I need to break it down. All right, so I inherited an IRA from my parent. Is the inherited IRA free from any creditors? All right, you must be very careful. There was a time where inherited IRAs could have been construed as creditor protected. And again, general seminar, but overall now they are not, right? They're inherited IRAs. They're not your traditional straightforward ones. So if you feel that you may have a creditor issue and you have an inherited IRA, you should come in and speak with us to see, what kind it is and what, if anything, we can advise you on. All right. Can I name the beneficiary of this inherited IRA, my revocable living trust, Can I name the beneficiary of this inherited IRA? So they have this inherited IRA and they want to name the beneficiary the revocable living trust, which by its terms has my spouse as the sole beneficiary. Okay. So you have to be careful again. So the general rule is, and this is general because there are some trusts with very, very specific provisions that allow you to name it. But the general rule is you want to name an individual. However, if you have a trust with very specific stretch provisions in here and qualify, there is a potential that you can. So my recommendation on this question is you come in, we review the trust, and we make sure it has the appropriate language so that you don't run afoul of any taxable rules. When you say and this is the next question, I've moved to the next one because I could see it in the screen. When your slide says IRA, does that include a 401 and a 403? Your qualified retirement accounts, whether it be a 401 or 403 or an IRA, should designate an individual, and if you have a spouse, as the beneficiary, typically not an estate and not a trust, unless it's subject to very specific provisions. Okay, so I hope this was helpful. Happy Valentine's Day. I hope everybody's spouse is good for them. And I really want to thank you for taking your time this afternoon to join us. I know we were briefly together. Maybe I'll do a part two, but I enjoyed our time, and I hope you have a really great day.
All right, thanks, Kim. I'll go ahead and close this up here. Really quick, what makes us different? Our clients tell us it's our dedication, accessibility, scope of legal services, and all the experience that gives them the peace of mind and confidence to work with us. Russo Law Group is a boutique firm focusing on areas of elder law, special needs, estate planning, and estate administration since 1985. We have three office locations and 11 attorneys. We've helped over 17,000 families, and we ranked as a best law firm in the area of elder law by the U.S. News. For upcoming events, we invite you to join Kim and Tom Morosco for their seminar on estate planning, protect yourself and your family. It's at Stella's Restaurant in Belmore on March the 21st. You can enjoy a complimentary lunch and learn all about the essential estate planning documents, long-term care and estate tax planning, and asset protection for your family. Just visit our website to register. I'm going to go ahead and drop that link in the chat as well. There you have it. Hope to see some of you there. Finally, a list of the services that we provide and how we can help you and your family. So that about does it. Please leave us your feedback in the webinar survey. In case you missed any portion of today's webinar, we are going to email you a link to the recording. Kim, brilliant as always. Thank you.
Thank you. Thanks,
And
everyone.
yeah, stay safe.
Bye.
Bye-bye.